Today I'm going to be discussing the right to trial by jury as guaranteed in the Sixth Amendment of the U.S. Constitution, specifically in light of the Supreme Court's recent decision in Ramos v. Louisiana. In the Sixth Amendment, all criminal prosecutions shall have the right to a speedy and public trial by an impartial jury. The concept of an impartial jury stems from a technical common law understanding dating back to the 14th century England that informs both the content and requirements of a jury trial. But which pieces of impartial jury trials carried with the Sixth Amendment and which pieces were dropped? Particularly, I will focus in on whether the right to an impartial jury includes a requirement that all jurors must unanimously find the defendant guilty. Historically, the common law understanding of an impartial jury trial included 12 freeholding men, unanimity, and a requirement that the members be local. But in Williams v. Florida in 1970, the court decided that the 12 freehold men requirement was not of constitutional stature. The requirement was removed because contemporary understandings of juries no longer required land ownership, nor did it require that the jurors be men. Thus, states were allowed to have criminal juries as small as 6 people. In Apodaca v. Oregon in 1972, the Supreme Court debated the constitutionality of non-unanimous jury verdicts. Did non-unanimous juries serve a valuable function in contemporary society without violating the Sixth Amendment? Or did the Sixth Amendment intend a unanimity requirement to protect defendants? In the end, the court narrowly ruled that non-unanimous jury verdicts were constitutional, but the decision and the rationale for the decision were so splintered it left many states and courts confused as to its precedential value. Most of the issues stemming from Apodaca are rooted in how the decision was laid out. Half of the court believed that trial by jury required a unanimous jury, while the other half believed that non-unanimous juries served an important practical function in our system. But it was Justice Powell's quirky approach that carried the majority opinion that non-unanimous jury verdicts were constitutional. Powell believed that the Equal Protection Clause under the 14th Amendment should apply in a strict manner to the federal government, but in a more relaxed approach to the states. Never before, and never again, has any Supreme Court justice used Powell's two-track approach to incorporation under the 14th Amendment. Thus, Apodaca's precedent was on shaky ground when non-unanimous jury verdicts returned to the Supreme Court this past term. By the time the Ramos decision was being heard by the Supreme Court, the state of Louisiana had recently removed non-unanimous jury verdicts through a statewide referendum. That left Oregon as the only state still allowing non-unanimous jury verdicts, and even Oregon had begun the public debate about whether or not to keep non-unanimous jury verdicts. On its face, it appeared as though the concept of non-unanimous juries were on their way out of the American legal system. But amici briefs filed by over 14 states expressed an interest in passing legislation allowing non-unanimous jury verdicts in criminal cases, pending the court's decision in Ramos. Of those states, many cited the appeal of saving money, saving time, and prosecutorial resources by avoiding hung juries, even if those savings came at the cost of individual civil liberties. In Ramos v. Louisiana, the court decided 6-3 in favor of Ramos, striking down non-unanimous jury decisions in criminal trials. Like the decision preceding it in Apodaca, the rationale for Ramos was scattered. Members of the majority of the court traced the history of non-unanimous criminal jury verdicts to its racist roots. Oregon passed the measure after the controversial trial of Jacob Silverman, a Jewish man that was one vote short of receiving a murder conviction in 1933. As a result, Oregon changed its laws with the support of local legislators, the press, and public anger to avoid having non-white persons who were quote-unquote unfit for democratic institutions from impacting jury outcomes. Louisiana's state convention of 1898 explicitly listed the purpose behind non-unanimous juries as a way of diluting the votes of African American jurors. Those jurors had just recently been granted the right to participate in trials as a result of the Reconstruction Amendments. The president of Louisiana's convention stated that their goal was to, quote, assure white political supremacy. By allowing non-unanimous jury verdicts, a majority-white jury could ignore the voices of minority, non-white jurors in upholding a conviction. The roots of non-unanimous juries were clearly discriminatory and a direct response to the political changes of the Reconstruction era. Non-unanimous juries are highly unlikely to return to the American legal system after being squarely and conclusively addressed in Ramos. The Ramos decision overruled a practice that had stood since the late 19th and early 20th centuries. This decision left some Supreme Court scholars wondering what other jury trial rights might be at risk. While unlikely, the court could return to consider reinstating the 12-person jury requirement removed in Williams v. Florida. Similar to Apodaca, the decision in Williams was centered around practical reasons and was decided merely 2 years earlier. However, that 7-1 decision would carry significantly more precedential weight, and the decision was not fragmented. In the end, the court's turn in Ramos utilized historical context to undo a misstep in Supreme Court jurisprudence. This decision restored our unanimity requirement that had been a hallmark protection for criminal defendants federally since the founding of our country, and in 48 states had been followed in kind. Thank you.